Hey guys, welcome to Hughes History. We're going to hit you up with a Supreme Court case, U.S. versus Morrison, a muy importante court case when it comes to defining the Interstate Commerce Clause in the 21st century. So whether you're in AP Government, a political science class, maybe you're in law school, maybe you're just cray-cray on the internet, maybe you just like doing the learning. I don't care why you're watching. We're going to go do the giddy up for the learning and go get her done right now. So this is a court case that's really about federalism, the balance of power between the federal government and the states. And specifically, what we're really going to be addressing is the use of the Commerce Clause, or the Interstate Commerce Clause, which is found in Article 1, Section 8, Clause 3, and it gives Congress the power to regulate commerce with foreign nations and amongst the several states and the Indian tribes. But it's that amongst the several states, when paired with the Elastic Clause, which says that Congress shall have the ability to pass all laws necessary and proper of their foregoing power. So when you take those two and put it together, Congress has created an ability to regulate things that you might not ordinarily think the federal government could regulate. So for instance, the 1964 Civil Rights Act, which bans basically discrimination in private institutions, private businesses, that uses the Interstate Commerce Clause, because the idea is there's a substantial impact when African Americans can't travel, when they can't stop at a hotel and put their legs up and get some sleep. So using that logic, that's how that law was passed. So now, fast forward to the year 2000, and we have an instance where Congress is passing a law, the Violence Against Women's Act, that is trying to address not only violence against women, but state bias when it comes to these kinds of court cases. Now, most of the Violence Against Women's Act is not being addressed in this court case, U.S. versus Morrison. There's federal rape shield laws that are part of that. There's different funding mechanisms that go to, gender-based violence programs, that sort of thing. But one part was meant to address what was seen as the state bias against women that were suffering from these crimes. And Congress basically is taking the 14th Amendment for equal protection under the law, and they're saying, you ain't doing that, Mr. State. Alabama, Alaska, Arizona, Arkansas, California, Colorado, Connecticut, Delaware, Florida, Georgia. You're not doing that right. And they have binders of data to show that there's inadequate investigations when it comes to sexual assault cases, that the sentences being given out are quite lenient, that there's a focus on the victims of the crime and going after them in state courts. So using that information, they're saying we need to do something. And we're going to do that using the Commerce Clause, because when there is this type of impact on women, there's a substantial impact on interstate commerce as well. Women, when they're victims of crimes, they drop out of college, they lose their jobs or leave their jobs. There's an impact on the economy when it comes to interstate commerce. So part of VAWA, the Violence Against Women's Act, gives women the ability to go to federal court and sue their attackers in a civic manner. And that's the part that's being challenged. That's the part where the states' rights advocates, the 10th Amendment advocates, the ones that say, you going too far, are going to say you've gone too far, and they're going to go all the way to the Supreme Court. So why don't we take a look at the actual case, the facts of the case, and then what the court's logic is going to be to strike down part of VAWA, the Violence Against Women's Act. So let's start with the facts of the case, because someone has to have standing. There has to be an actual case. And a young woman claims that she has been raped multiple times by two men at Virginia Tech. One of them was James Crawford. The other one's name was Antonio Morrison. There is the person in the case. And even though the school suspended Mr. Morrison and he admitted to it, he was actually overheard bragging that he enjoyed attacking drunk women, the case actually fell apart when it went to the grand jury, and no charges were ever filed. But there was a lot of evidence that the rape actually occurred. So using this new part of the Violence Against Women's Act, this young woman is going to take Mr. Morrison to court and sue him for some bucks. Now, Congress created this section basically, like we talked about before, to make up for the bias in these state cases. The thought process being the states would take them much more seriously if this new avenue existed to go to federal court. So at first the court case is overturned, it's then upheld, it's then overturned again before it makes its way to the Supreme Court. And the Supreme Court is basically going to say that Congress has overstepped its ability to regulate interstate commerce. And they're first going to call attention to a very important case called U.S. versus Lopez. right there. That's a very important court case of 1990. And this was a court case that struck down the federal law, which was the Gun Safety School Zone Act, which basically banned the ability for anyone to have a gun within a certain amount of distance from a school. And the court said, hey, that's not really affecting interstate commerce. If we don't draw a line, there will be no line to be drawn. And therefore, basically, the federal government could rule everything, that the states would have no power if Congress eventually used the Interstate Commerce Clause to keep expanding their power. And in U.S. versus Lopez, they said, look, you either have to be a channel of interstate commerce, like a highway, or an instrument of interstate commerce like a car on the highway, or there needs to be a substantial impact on the economy when it comes to interstate commerce, like the 1964 Civil Rights Act. And they say that basically the Violence Against Women's Act just doesn't have that. And the court agrees there's a problem. They agree that there is state bias, that women are not being treated equally. But when the court comes to its justifications, it's going to say, first, there's something called the state doctrine, which comes out really of the 19th century. There was a court case called U.S. versus Harrison, 1883, and a bunch of cases called the Civil Rights cases of 1883, where the court said, you may go after the state when it comes to unequal protection. You can go after Alabama, but you can't go after the individual that discriminated against. And that's what's occurring here. You're not going after Georgia or Virginia because they're discriminating against women, which they shouldn't. You're going after the individual people in the state, the citizens of the state, and you don't have the ability under the 14th Amendment to do that. And when we go to the Interstate Commerce Clause, they're going to point to U.S. versus Lopez. They say, look, obviously you're not a channel of interstate commerce here. You're not an instrument of interstate commerce here. And there's no substantial economic impact when this happens to women. That's what the court decides. So they say, look, if you want to go after the state, that's one thing, but you can't allow people to sue somebody that's a state matter in federal court based on this muddled pairing up of the 14th Amendment and the Interstate Commerce Clause. This is a 5-4 decision, so by the skin of their teeth, the conservatives are going to win this one. It's a court case that's been decided by Rehnquist, who was the Chief Justice. We have Clarence Thomas, we have Sandra Day O'Connor, we have Kennedy, and we have Scalia that are all grouping together to stand on the idea of states' rights. So that's basically it. What we've done is we've shrunken, is that a word, shrunken, the ability of Congress to use the Interstate Commerce Clause paired with the 14th Amendment and the Elastic Clause to pass these sorts of laws. If you're going to pass a law, the court says that it must have a substantial impact on interstate commerce. So we hope that you understand that. That's U.S. versus Morrison. We even threw a little U.S. versus Lopez in there. How kind of me. We certainly hope that your brain's a lot bigger, and we certainly hope that you subscribe. If you haven't done that, you should go do that right now because it's the right thing to do. And I'm going to say it because I say it at the end of every lecture I've ever given, where attention goes, energy flows. We'll see you guys next time that you press the buttons.